Hi guys, so today I have a quick legal tip for you, especially for those parents who are thinking about leaving property to your children. I know that a lot of times when parents are thinking about leaving property for their children, the first thing that comes to your mind is to make a will. Now today I'm going to share with you why transferring the property to your child or children while you are alive may actually be a better option for you. First things first, when you leave property for your beneficiaries, which could be your children or anyone, it doesn't even have to be a relative. That beneficiary can only claim ownership after you die. Whatever you put in the will only come into effect after you die. So if you leave property if you say, okay, I'm leaving entire property, house and land to Tom, my son, then this will only come into effect after you die. Now, this is not an automatic process either. If it is that you left a will, whoever you chose to be your executor will have to make an application to the court for probate if the land you're passing is registered land, or letters of administration if it's unregistered land. No, that's the first step. So the thing is, probate or letters of administration can take several months, even years, especially if there are challenges to the will that you left. But them other relatives who say, oh, no, this not because are me supposed to have some interest in this. Yes, that can extend the process a lot, right? And as you know, time is money, so more time equals more money. However, if you decide that you have your one picnic or two picnic or three, it doesn't even matter. You can transfer the property to yourself and that child while you are alive. I know that might sound a bit confusing, so let me explain. Transfers while you are alive are called inter vivos transfer. Now, if you decide to gift your beneficiary land while you are alive, like when you're completing the transfer document or the instrument of transfer as we would call it, you would put your name as well as the beneficiary's name. That would mean both you and the beneficiary, for instance, you and your son, will still be owners of that property. And then once you have passed, assuming you've passed before the beneficiary, there is something that comes into effect depending on the conditions that you have used to transfer the property, whether it's by tenants in common or joint tenancy. If you decide to transfer property to yourself and your child as joint tenants, then once you pass, the right of survivorship will come into effect, and that child will automatically become the sole proprietor, sole owner of that entire property. Now, let me just clarify what automatic means. Automatic doesn't mean like, okay, so you die and then the titles office is just gonna know that, okay, your son Tommy is the sole proprietor. No. Tommy will then have to just take your death certificate, apply for a notification of death, just to notify that, okay, you have passed away, and now he's the only joint tenant that is remaining, and therefore the only owner of that estate. Now, tenants in common is slightly different. This allows you to decide how much of the land you want to give to who. Now, what does this look like? So you have 3 children. You can transfer to yourself and your 3 children as tenants in common. This means you would decide how much share of the land each person is supposed to get. So if you want to transfer to yourself 25% and then 25% to each of the other children, you can do that. That way, if you pass on, what you would do, you can then put in a will who should get your 25%. Because when you do tenants in common, this allows you to will your share. If you do joint tenancy, then you cannot make a will, because based on the law, if you're a joint tenant and you pass on, you cannot will away the property, because automatically the next joint tenant is supposed to get that. You get what I'm saying? But if you do tenants in common now, whatever share you have, the 25%, you can put that in a will, that portion in a will, to whoever else you want it. But at the same time, because you had already transferred while you were alive 25% to each of your 3 children, when you die, your death does not affect their each of their 25%. And when each of them die, they decide how they want to treat with their 25%. So I don't want to complicate it too much or get too deep. It's going to take a lot of time for me to explain every single thing. And then at the same time, everything varies. Every case, we have to look at it on its own facts. So your situation might be totally different. This might be the worst idea for you because you probably have some covetous bad broke picnic who really and truly you don't even want them to know say yeah leave anything for them. You get what I mean? So this may not be ideal for everyone, but I'm just sharing because this is a way where you can actually save money. Listen, to go through the process of probate or letters of administration is not cheap. I have clients right now who are struggling because legal fees alone, just to start, first of all, legal fee for probating right now is like 3% of the value of the estate. So for instance, if you have a piece of land that's valued $3 million, just to pay your attorney is going to be about $300,000 to start minimum. Okay, so keep that in mind. And separate from that, you do have other fees that will add up over time. Application to the court, drafting, reviewing, everything. Not to say to transfer while you're alive, which are called inter vivos transfer. Not to say these does not cost, because you do have to pay the transfer costs. But what I can tell you for sure is that it generally costs less than what you have to pay over the duration of a process of probating or doing letters of administration for wills. So when you're doing these things, it is important to speak to your attorney to find out what is the best process for you, what is the best strategy, or what suits your situation best. So that's it for now, guys. Listen, when it comes to property, it is very serious, so always consult your attorney at law to see what works best for you. Thank you so much and have a great day. Bye.